welcome to the YouTube channel Lex Consilium Foundation and the playlist Insibilie. In conversation here with Justice Bashir Ahmed Khan. He's come here earlier. He was the Chief Justice, J&K High Court in 2005. Welcome, Justice Khan. We have something very important and significant to our country as a republic and in the judicial field. You would be aware about the observation, the speech made by Justice Ujjal Bhuyan of the Supreme Court at the ILS College in Pune. During the course of his speech, he referred to the action by the Collegium of the Supreme Court to transfer him, having once issued the orders for his transfer from Madhya Pradesh to Chhattisgarh, and thereafter it was reconsidered and he was shifted to Allahabad High Court. This matter, the resolution of the Supreme Court Collegium was indicated in the website, and there it was mentioned that it was at the request of the government. Now, this part was subsequently removed. Very shortly, while speaking about it, Justice Ujjal Bhuyan of the Supreme Court said that he called it a striking intrusion. Now, this paper has been, this news item has been covered widely. You would have seen the montage, and so I'll not take the time on that. The Times of India came with an editorial calling judging judges, and Indian Express also said that Supreme Court judge indicating to Justice Bhuyan that he has slammed Collegium for transfer on government nudge. Now, with this, we will come to our discussion here today. Now, my first question to Justice B.A. Khan is that does government routinely influence or interfere in the transfer of High Court judges, as has been indicated or hinted by Justice Ujjal Bhuyan, and if it is so, to what extent?
Thank you, General Saab. Before I answer your question, I am reminded of a verse by Parveen Shakir, is a poetess in Pakistan, because on this Justice Ujjal's remarks in a speech at a law college, which has spread all over. I don't know how long you are interested, how far you are interested in music, but this is sung by Mehdi Hassan, and it's a very famous ghazal all over. On this Kubuku baat phail gayi shinasai ki, Kubuku baat phail gayi shinasai ki, baat to sach hai magar baat hai ruswai ki. Whatever Justice Ujjal has said, बात तो सच है, लेकिन है बात रुसवाई की. रुसवाई फॉर होम, रुसवाई फॉर अस हु आर बिलोंगिंग टू द judiciary. Whether government routinely interferes in the matter of transfers or not, answer to that is yes. And because government is an essential component of the process of this transfer and appointment of judges. And it starts with the government and ends with the government. And in fact, government is the mover and shaker in this whole process. Now, therefore, to say that government is intruding or interfering may not be a correct expression to use. The government is participating in the process. Now, to what extent that process is justified or is not justified is a separate debate altogether. Now, when I say that government is participating, because without government, this process cannot be completed. For example, you transfer a judge. For that, you have to collect certain inputs. Now, those inputs are always collected by the agencies of the government, and those are fed to the collegium. After those are fed to the collegium, then a decision is taken of which government is very much of no. Or in most of the cases, it is the government who is the initiator of that process and that transfer till it is concluded. So whether government is intruding or not, I wouldn't say it's intruding, it is participating in the process, which it has been always doing. Now, may I tell you, General Saab, that this process of transfer was not within any collegium or within any Supreme Court ever. It was not firstly in the Constitution at all. It came by way of a 42nd Amendment, as you must be knowing, during emergency, when judges were hired and fired, and it became necessary to shift or transfer inconvenient judges from one place to another place. That it is that time that Article 2 was inserted in the Constitution. And that article says the President may transfer a judge of the High Court from one High Court to another High Court in consultation with the Chief Justice of India. Now, this word consultation was later interpreted, that's a separate chapter, I will come to that later on, was interpreted to be meaning as concurrence, which means that concurrence of the Chief Justice for such a transfer was necessary, which ultimately led to the coming into existence of Collegium and so on and so forth. So, what I am trying to say is that this is not an intrusion, this is a participation in a process of transfer of a judge. Yes.
जज साहब मैं जो मेरा सवाल था उसकी ओर आ रहा हूं एंड वी विल restrict ourselves to the constitutional provision as it exists now. And participation may mean furnishing necessary inputs about a judge. But the question is, does the government interfere and influence? That's my question. I would request for your comment. Participation by supplying data is okay. Participation by way of ultimate notification by the president, fine. But does it influence and interfere?
It does. Answer is yes.
Okay,
And it is behind the curtain interference.
right. So
This is not a visible interference.
Okay.
And this is as much known to the Supreme Court or to the Collegium, whatever you may say, and to everybody else working in the judiciary. So it is there, it has always been there, and it is inevitable in a way. Because in the whole process, it is the government which is the mover and shaker. So these are all, I think, these are all alluded. No, this is a myth and independence of judiciary, it is impacting and so on and so forth. Minus government participation. Now, to what extent it participates? Does it influence? It does influence, yes. Does it influence constructively or negatively by way of a punishment? That is the debate. And that should be the debate. Where it interferes to gain its own thing. For example, an inconvenient judge. You were just now talking about Justice Sreedharan. An inconvenient judge, if he is to be removed, then government is using this power of transfer as a instrument of punishment. This is not used for the interest of administration. It is used as instrument of intimidation of justice. Please note this. It is used as instrument of intimidation of justice, not administration of justice. So it all depends on what kind of a use you are making of this weapon of transfer. If you are weaponizing this transfer, and this sword of Damocles, it hangs on the head of every judge till he is a judge in a particular high court, because he knows that if I do this, then the consequence will be this. And this is a phenomena which is afflicting the high court judiciary today. And there are no two ways about it. And it has to be admitted. I mean, you can't put it under the carpet and say, no, everything is okay.
Now, we are discussing here, Justice Khan, about administration of justice, for which the judges are a very necessary ingredient component. And therefore, my question is, as you have indicated that the government does interfere, government does influence, is it provided for under the constitution or under the law?
Yes, technically, if you say that no, it has been power taken away and it's now with the Collegium and any government intervention is an interference, you may be technically correct. But basically and essentially, the power lies with the government, because Article 222 provides that it is the president who may make a transfer of a high court judge from one high court to another, with the consultation of Chief Justice of India. Consultation was not that time till it came to be overstretched by an interpretation by the High Court in the Advocate on Records case. Consultation till that time was not meaning concurrence. Collegium has come into being how? By placing an overstretched interpretation on this word consultation. And Supreme Court has taken it upon himself, taking out this power from the government and taking it upon himself to make appointments on the ground of independence of judiciary, and consultation means concurrence of the Chief Justice, which concurrence has been now expanded to mean that it's a collegium of 5 judges, not one single individual of Chief Justice. So essentially the power lay with the government. this is a power which has been taken away by an interpretation by the Supreme Court in a judgment. The judgment is a law of the land today. And on that judgment, there have been so many debates. We have been holding debates on appointment of judicial commission also, which has been also struck down by the Supreme Court on the ground of independence of judiciary. So what I am saying is that the government is not a stranger to this. It is the government is the essential party in a way. Question is only the manner of exercise of this power. If the manner is bad, if you are using it as punitive, and if you are disturbing the contours of the independence of judiciary, then no. But if you are using it in certain situations, you can use it very beneficially. For example, you have an awkward situation given arising out of a judge's conduct at a particular place. For example, his kin are involved, or his relatives are involved, or his businesses are involved. Or, for example, he is under a local influence of the local leaders, political leaders, or business people, or, for example, of his own lawyers, and so on and so forth. And to rescue such a situation, to deal with such a situation, transfer of that judge becomes necessary. And that becomes necessary because you have to remove the man from that station. So in that case, you can't say that no, the transfer is a bad thing or it is interfering in the independence of judiciary and so on and so forth. So there are situations where a transfer may become necessary, but if it is bona fide used, then yes. But if it is mala used, I give a judgment according to my whatever perspective or whatever my knowledge of constitution or whatever, and it goes against the government, and you are annoyed of it, just as happened to this Justice Sreedharan, then you are using it as a weapon of punishment. That is not countenanced in either in constitution, nor should that be put up with the concept of the independence of judiciary.
I'd like to move to, although you have already covered it, when does the necessity of transfer arise? Is the need for a transfer indicated, initiated by the judiciary, or is it the government which feels and initiates a case that do consider transfer of a particular judge? And in that, I would also like you to please clarify that the need to transfer a judge, does it also include an authority or a power to indicate that move him to a particular high court?
Well, then, sir, that is something which falls in that statecraft, I say always, and which is sorted out in a mutual discussion, and which is not known to the in public domain. Now, what are the situations where transfer becomes necessary? I have indicated some.
Yes.
For example, a judge is involved in a scandal, as you had that Delhi judge where you found the stacks of cash in his residence and all that. Or it may be judges involved in some other thing, or patronizing some business people, or working at the instance of politicians, which generally happens, of which I have an experience. Now, in such a situation, or we had, if you remember, we had Justice Manikadachalaya. When he came, he found that judges were almost becoming semi-gods in their own dominions. So he introduced a mechanism called for national integration, transfer two-thirds of judges from every high court. So that two-thirds theory came in the name of national integration. Now, depending on what this policy was again discussed and debated, and it was agreed by both the Chief Justice of India at that time, Mr. Venkatacharya, and the government. And it was agreed, yes, for purpose of national integration, a judge from Kashmir should go to Kanyakumari. So that will lead to some kind of a national integration. Now, that led to an abuse of power in so many cases, and lots of humanitarian situations were so much aggravated by this kind of a decision. I remember one lady judge from Madhya Pradesh, Justice Saxena, whose husband was a cancer patient and who had nobody to attend to her except this lady who was a judge. She was transferred to Chandigarh. And she went from pillar to post that I want to save my husband. Please allow me 6 months. I will see whether he survives or dies. Then she was not allowed. Now, those were also situations in which the power was misused. So there are situations where it becomes necessary, maybe for national integration. You must have recently heard that number of judges were imported to Delhi High Court. What was that? We are very jealous of preserving the character of the Delhi High Court, so to say. And there is a lot of resistance when people from outside are brought to Delhi High Court. A separate culture, a separate outlook, a separate. You must have last time noticed how many judges were imported to Delhi High Court. And what was the idea behind it? Not national integration. It was to neutralize the outlook of Delhi High Court, which is it is known for. So today you have a mix of all types of judges in Delhi High Court. Similarly, it happens in other high courts also. So what I was responding to is that there are situations where it becomes necessary. It all depends on what kind of purpose you want to achieve. If you want to use it as a punishment is one way. If you want to use it for the benefit of the judiciary, for the good administration of judiciary, for independence of judiciary, very welcome. Then transfer is a good method to do it. But there are people who are prepared to suffer. You have Sreedharan who has gone through 4 high courts in 4 months. But he will not budge from it because he is made of a metal where he will go by what he believes to be the right thing to do under the constitution. So there are some people like that.
Moving from your remarks here, would you like to say that there are 2 types of transfers, good transfers and bad transfers?
Yeah, good transfers are those transfers where you do it for the benefit and sake of the independence of judiciary. You remove or shift a person from one place to another. For example, a person having his kith and kin. For example, a person having a scandalous working at a station. Now, those are good transfers. Or, for example, I forgot to tell you that initially, Chief Justice's from outside transfer policy was not there. Now, when it was introduced for what? It was introduced because the local Chief Justice was indulging in all kinds of things.
Sir, I'd like to just bring out Justice Khan that in case if the transfer is being resorted to shift a particular judge who's said to be, say, inconvenient or inefficient, then there have been instances when at the receiving end the bar has protested that why should we get a person who's inconvenient at that location, and they have written, they have sort of agitated. Those instances are there. And on this channel, late Fali Nariman had commented, and he had pointed out an instance of Bombay High Court, and he said, that is Fali Nariman, that the best way or a better way to deal with a judge, in case it is to be done as a punishment, he said divest him of all judicial work, and that was done in Bombay, and he felt that it was found quite useful. Anyway,
but those are cases.
That may be an opinion, but I'd like to ask you that is this process of transfer, according to your perception, used by the government to keep the judiciary under check?
100%.
It is so.
100%. I have already told you that it's used as a sword of Damocles, which is hanging on the head of the judge all the time.
Fine. Now,
because the motive behind using this power is not bona fide. It is always for purposes for which government wants to benefit. Maybe not facing an adverse judgment could be, or maybe an upright judge working in a manner which is creating problems in the implementation of the government's policies. That could also happen. So those are the inconvenient judges we call. So therefore, it's all the time a threat. It's all the time hanging on your head. Irregularities, whatever, benefiting his own people and so on and so forth. Now, what has it come to now? And that time it was being made only by the judiciary. That transfer chief justice was selected to go from one place to another place only to check his localism. Now it has assumed a different shape, form altogether. It is what? That you must have a chief justice at a station who is working at your bidding. Because chief justice controls roster, he is the master of the roster. On him, there are a number of things depending. So even in Chief Justice's selection and posting, the government has an upper hand. And there is no one in the collegium standing up to say that no, on the ground of suitability, that this man Home government is wanting to be posted, say at Delhi, will not be a suitable person there. Nobody to say that. So even in that, much of the selection is done behind the scenes by the government, and you will find Chief Justice posting today has also been taken away from the hands of Collegium or judiciary. They select a man that's easy because he is the senior most to be the Chief Justice. But where he should be posted depends on other considerations, which I call the considerations of statecraft. So this is about good and bad transfer.
Now, theoretically or apparently, the transfers are meant to be affected in the interest of administration of justice. What does government gain by transfer?
Government gains everything. Government gains to clear the path for its functioning for working. Government gains to, if you have a pliable judge somewhere, to get favorable orders. Government gains to remove an obstacle if you have somebody like Sreedharan somewhere, remove the obstacle. So government gains, or if you want to punish somebody. Jalsa, what can I tell you? Transfers are made at the instance of businessmen. Transfers are made, you have seen at the level of political leaders. This Madhya Pradesh transfer, this Sreedharan transfer. But even a contractor can get you transferred. Can you believe that? A big businessman can get you transferred. There is no surprise on that. Why? Because you may not have given him a favorable order of a city against his income tax arrears or whatever. This is happening, and this has happened. So where do you draw a line? Draw a line. So government benefits. That is why the provision of transfer. What was the need otherwise? Before this provision was introduced, it was all smooth. But since government is wanting to have a control, that is why this transfer is weaponized. So when it is weaponized, it becomes bad. When it is bona fide used, it becomes good.
In the scheme of things, as of now, there is Collegium and the Collegium is functioning. I would like you to please explain to the viewers that the government intervention, you have used the word participation of the executive. Now, the participation by the executive, does it impact the dignity and decorum of the Collegium and thereby affecting their credibility? What are your views on that regard?
जनरल साहब, tell you honestly,
हाँ ऑनेस्टली बताइए.
ऑनेस्टली क्या बताऊं आपको, वो डेकोरम डिग्निटी कहाँ रही है? हम तो गोदी में बैठने वाले सब हैं. ये कहाँ, देखिए, डिग्निटी डेकोरम तब रहता जब मैं इंस्टीट्यूशन के लिए खड़ा हो जाता. इफ आई कुड स्टैंड अप, इफ आई वाज अपराइट एंड से व्हाई आर यू ट्रांसफरिंग Sridharan 4 times in 4 months, then one could say, look, that is the dignity of the so and so. But where is that? That's not happening. And nobody is prepared to. Why? Nobody is not prepared to. Again, we come back to the same thing, same expediency, same pliability, same human weaknesses, same being vulnerable to this and that, same being guarding against doziers, advised. Do you know that doziers are prepared on every judge? And do you know all agencies are watching a judge every time? And do you know how he is confronted when he is confronted with a dossier of an agency report? क्या करेंगे उसमें? I mean, you can't, but still we are better off, I tell you. If you look at other countries, for example, in the neighboring country, if you see, conditions are worse. There you can't fix a date without asking the field commander. Now, this thing is happening. It's a part of I call it part of the game. And it is being naive to cry horse on such things. And I think Justice Ujjal is a new man to Delhi. He has yet to taste the Delhi bazaars. And by, if you have time, I can tell you one anecdote.
Yeah, please go ahead.
I was a newly appointed judge like Justice Ujjal. There was one collector in a Punch district that's called Punch. That fellow would disobey and violate High Court orders on the drop of the hat.
Ji.
He would tell the judge, do whatever you want to do. So that file was sent to me because I had a little assertion of putting the. Now I called that officer. He was not first coming to High Court, and no judge was trying to bring him to the High Court. So I should have got him to the High Court. I told him, why are you not obeying these? 5 times, 6 times you have been told by the High Court to. And he had issued an order that irrespective of the High Court order, I am not going to do this, which was a blatant contempt. I said, why are you not doing this? So this is a very bad situation. Now, if you tell me what to be done, he said, sir, I am not going to do this. You do whatever you have to do. I will do whatever I have to. I said, all right. I fixed the case next week. And next week, I said, if you have anything to say next week, by next week, say it. Then next week, I will decide whether you will say it or you will obey it or you will not obey it. Can you believe, General Saab, in 2 days' time, that file disappeared and was assigned to another judge who was a very cozy judge at my back. The date I had fixed, I called the registrar, I find no file there. He tells me, sir, that matter has been disposed of. I said, how did you do that? That case was listed before me. He said, sir, Chief Justice has withdrawn that case. I was so furious. I went up to the Chief Justice. I had a very high respect of him. I said, did you make us a judge for this only? He said, what happened? I said, how have you removed the file from my list to the other judges list? He said, don't raise your blood pressure. थोड़ा थोड़ा टाइम में सीख जाओगी. मैंने कहा मुझे क्या सीखना, हमको तो ये पता था कि इंडिपेंडेंस ऑफ जुडिशरी है, ये है, वो है. कहा नहीं नहीं, सीख जाओगे, आगे आगे सीख जाओगे. कम हैव अ कप ऑफ टी, डोंट रेज योर ब्लड प्रेशर. यही बात है सीखने की. आज जो ये भाषणबाजी हो रही है, it doesn't hold true when it comes to the ground reality. And ground reality is what? Ground reality is that both judiciary and government can't work exclusively. There is no way of working exclusively. They have to work jointly. The only thing, bad part of it is when government exercises that, abuses that power and indulges in these negative weapons.
यहाँ पर जैसा मैं आपसे इल्जा करूंगा कि ट्रांसफर ये कहा जाता है कि इट इज एन इंस्टेंस ऑफ द सर्विस. नाउ हाउ इज द ट्रांसफर ऑफ जजेस different than transfer which takes place for all government servants? Because some of our viewers may not understand this, therefore you have to explain the nuances of this. How is it different?
General Saab, transfer of government service servants is better off, far better. They have all the rights, they have all the amenities, they have all the grounds on which a transfer can be made. There is nothing arbitrary. When a government servant is transferred, he seeks a remedy in the court, and we in the court look into on what ground he was transferred. Was there any malafide? Was there any bias? Was there any prejudice? Was there any suitability lack? And was it according to every government servant department as a transfer policy? Was it in accordance with the policy? For example, policy says don't remove before 2 months, 2 years. Was he removed before 2 years? Why was he removed before 2 years? Stay. Transfer nullified because an officer may dislike his subordinate. Transfer. We say stay. We say stay. Who says stay? Court. Judge. And when it comes to judge's transfer, where does he go? He doesn't go anywhere. There is no policy. There is no ground. It is all hire and fire. It's all likes and dislikes. It's all who takes the advantage, who doesn't take the advantage. It's all to assert your this power of intimidation on the judiciary so that you are controlling it. And where do you go? You don't go anywhere. Why? Because your Supreme Court itself by a judgment has said you have no remedy. You can't challenge it. You don't take even the consent of the judge. When you send him to Nicobar, that fellow may not be in a position to go. His father might be dying, but he has no one to go to. Where will he go? To whom will he tell that my father is dying? Nobody is prepared to listen to him. He can't go to a court. He can't file a writ petition. So this is so arbitrary. This is so full of malafide, and lots of transfers emanate from malafide. Malafides are whether these are political considerations, whether these are dislikes within the judicial community, so on. But there is no, that is why I say, if you ask me, if I can adjudge a government servant's transfer to be bad on the ground of malafide or bias or whatever, why should I feel helpless when I am transferred? You give me the same right. In this case, a judge's all rights are taken away. Judge has no right or taken away when he is transferred from one place to another place. He can't file a case. He can't make a representation. He can't go to meet somebody. He can go and meet the Chief Justice. That Chief Justice is not granting you interview to meet. And you have cases where sick people were moved forcibly to their other stations. If there is any uprightness, grain of uprightness in judiciary, collegium or Supreme Court, If they have any courage, you take an oath of being fearless and this and that. Then evolve a policy, evolve a transfer policy, because a judge enjoys a security of tenure. How can you ensure him to, how can you expect him to pass orders without fear and favor when your sword is hanging on him? So, evolve a policy, which policy is consonant with the rights, with the provisions of the Constitution. You are indulging in the worst kind of arbitrariness by shifting a judge and telling him within 7 days, if you don't report, then you are gone. You are telling a high court judge if you don't do that. And where is your security of tenure then? So all these things, General Sahab, are
यहाँ
happening.
पर एक मैं दूसरा मुद्दा उठाना चाहूंगा। आपने ये आर्बिट्रेरीनेस की बात की और सिक्योरिटी ऑफ टेन्योर की, लेकिन प्रैक्टिस में अभी ये हो रहा है, जो कॉलेजियम के डिसीजंस हैं वो वेबसाइट पर आते हैं, लेकिन सवाल ये उठता है कि जैसे ये जस्टिस अतुल श्रीधरन का केस है, इसमें ये नहीं पता चलता, ये नहीं मालूम किया जा सकता कि क्या जो कॉलेजियम का डिसीजन यूनानिमस था या किसी ने उससे इत्तेफाक नहीं किया, वाज देयर अ नोट ऑफ डिसेंट, ये क्यों नहीं हो सकता है? व्हाई इज
उससे क्या
ट्रांसपेरेंसी नॉट देयर, एंड व्हाट कैन बी डन टू ब्रिंग इन, टू अशर इन ट्रांसपेरेंसी?
जनरल साहब, यू आर टॉकिंग अबाउट ऑट टू बी, होना चाहिए था। जब हम लोगों के, when we are deciding people's rights, how is it that our own right is not being decided or is not being heard? Should have been the thing. But it's not like that. आपको पता क्या बोलेंगे?
जी,
Do you remember that lady judge in the Supreme Court who recorded her dissent in writing against the elevation of a Gujarat High Court judge to the Supreme Court, who is going to be a Chief Justice for 4 years? Do you remember that? She wrote a dissent and she gave all the reasons in the dissent, saying that we are superseding 38 Chief Justices, judges who are senior to this man, and that this man is going to be a Chief Justice for so long. And this man has this roots, referring to those. I don't want to go to that. But then what happened? What use was her dissent? And if you do such a thing, let me tell you the inside of it. You are sidelined. You are sidelined, and go and preach your principles and uprightness in your chamber every hour. That is statecraft. So what do you do? So even if there should have been a transparency, transparency is there everywhere, but not in the, now you know what the argument is. Now if you tell Sreedharan that you have been transferred 4 times for this, oh, Sreedharan's image will get affected in the transferee high court. Look at the argument. In the transferee high court, it will get affected. What will get affected? Sreedharan was to come into Collegium in Chhattisgarh, to remove him from Collegium so that their own people can become judges. This reason can they give this reason? That is why it has been removed from the website. So in other cases, they will say, oh, if we give reason, what intelligence agency has fed us, then that will spoil the image of this judge. And wherever he goes, then he'll be looked down upon, and so on and so forth. He will lose his moral authority. And on that specious argument, they say, no, it has to be utmost secrecy and confidentiality, and no website, no transparency. If they are honest, if they are bona fide, let them prepare a transfer policy. If a clerk or a patwari under his transfer policy can't be removed for 2 years from one station to another so that he is dislodged, how can a judge be removed like that? Irrespective of what his condition is, what his condition is not. You are sending people to places where they don't know what the language is, what the food is like, what the culture is like, what kind of a national integration you are promoting. And this has happened. So you send a person to, say, for example, a place where he doesn't know the language, like court language. Get a South judge to North, send him to a Hindi state. There everything is happening in Hindi. He doesn't know what is happening. He can't deal with that case because he doesn't know. So, but in the name of national integration, you are doing it. So far, so good.
मैं ये भी आपको ध्यान दिलाना चाहूंगा कि जस्टिस उज्जवल भुयान की जो स्पीच थी आईएलएस पूना में, तो वहां उन्होंने कहा था, वी नीड जजेस हु कैन स्टैंड अप against political whims. Now, does this statement, this assertion that we need judges who can stand up, does it construe that we don't have such judges?
No, there are such judges, but they can't stand up. Now, there are judges, maybe very few.
बहुत कमी है.
They can't stand up because maybe they feel that no, it will not have any outcome. आप stand up करो, आपको साइड लाइन हम कर देंगे, जाओ बैठ के कहीं अपना चैम्बर में किताबें पढ़ो। या तो कलेक्टिव कॉन्शियस आपका ऐसा होना चाहिए जो स्टैंड अप हो। वो तो अगर कोलिजियम 5 मेंबरों का है तो पांचों का पांचों ये कहना चाहिए भाई इसको 4 बार क्यों कर रहे हो भाई, नो विल नॉट डू इट, मे नॉट डू इट। सरकार को गया, सरकार के वी आर नॉट पासिंग एनी ऑर्डर, उस ऑर्डर न पास करने के डर से करो अपराइट, क्या करोगे आप। दिस अपराइटेडनेस, आई एम नॉट सेइंग दैट देयर आर नॉट पीपल हु आर नॉट अपराइट, आई एम नॉट सेइंग दैट देयर आर नॉट पीपल, ऑल आई एम सेइंग इज दैट few people who are upright, few people who want to stand up, few people who are working fearlessly, those few people do not want to stand up and to suffer alone.
लेकिन जज साहब ये कॉलेजियम का कंपोजिशन तो चेंज होता रहता है, लोग आते
हाँ,
हैं जाते निकल जाते हैं,
हाँ।
तो फिर कलेक्टिव एक वो कल्चर कैसे हो गया है सबसर्विएंट दैट इट विल टो द लाइन ऑफ द एग्जीक्यूटिव, इसके
जंग
बारे
साहब
में आपकी क्या सोच है?
अंदर की बात बताऊं, ये जो कोलिजियम का है मामला, इसमें जब कोलिजियम इस सर्कल में दाखिल होता है, वो कोई ही इज नॉट समथिंग, कोई पहलवान थोड़ी वहां दाखिल होता, मामला तो ऐसे चलते हैं।
तो अब हम लोगों की जो बातचीत हुई यहाँ पर, जो मैंने आपको सुना, आखिर में मैं आपसे ये जानना चाहूंगा कि व्हाट इज द वे आउट?
वे आउट जनरल साहब इसको रैशनलाइज करने का है। इफ यू रैशनलाइज दिस, firstly you have to be honest enough at both levels, government level as well as judiciary level. Honest formation of a policy जिसमें सांप भी मरे और लाठी भी बचे, कुछ ऐसा। नहीं तो दिस हैज बिकम सच ए arbitrary Malafide exercise, that and for a high court judge, that high court judge who does justice to others in similar cases, अगर वो होता है, if they can frame a transfer policy, if that transfer policy gives you the circumstances in which a judge can be transferred, if that transfer policy gives you the tenure of a transfer, for example, एक वक्त ये आया था कि हम एक्सचेंज में एक जज को 5 महीने के लिए भेजेंगे या 1 साल के लिए भेजेंगे, समथिंग लाइक दैट। If those things are worked out so that a judge feels secure at his time, at his place, then it's okay. If not, then it is ये सब क्या इसी में है, वो क्या कहते हैं, it is all in, and we have no face to show. Being ourselves justice dispensers, injustice is done to us. ये देखिए कितना जुल्म है, और उफ नहीं कर सकता कोई। आपने देखा जिसपे नाइंसाफी जुल्म हुई आज तक जज पे, उसने कहीं उफ किया हो? आपको कलील कुरैशी का याद है? आपको पता है कितने जजेस को कट शॉर्ट कैसे किया गया? किसी ने उफ किया, कहाँ करेगा? बिकॉज ही हैज नो वे, ही हैज नो रेमेडी। ये दिस इज द स्टोरी ऑफ आवर ट्रांसफर पॉलिसी एंड द जुडिशियल फंक्शनिंग।
अपने पूरा जो आपका तजुर्बा अब तक रहा है, तो आखिर में आप आर यू ऑप्टिमिस्टिक दैट थिंग्स आर लाइकली टू चेंज और दे वुड चेंज फॉर बेटर?
नहीं, इसमें गुंजाइश नहीं है जनरल साहब,
गुंजाइश नहीं है?
ना गुंजाइश नहीं। बताइए क्यों? इसलिए कि देखिए हमारे जो ऑब्जेक्ट्स हैं वो इन कॉन्फ्लिक्ट हैं। सरकार का एक ऑब्जेक्ट है, उनको सरकार चलाना है, उनको स्टेट क्राइम में करना है, जुगाड़ करना है, रूल को इग्नोर करना है, रूल का उल्लंघन करना है, रूल को ब्रीच करना है, वो उनका वर्किंग में आ जाता है, और उसके बगैर वो आगे चल भी नहीं सकते हैं। ये सरकार का जो है ये मुद्दा बन जाता है, इट्स एन ऑब्जेक्ट। तो उसमें अगर जुडिशरी का जज रास्ते में आता है, उस जुडिशरी के जज के साथ उसको निपटना है, तो वो निपटने के लिए क्या क्या हथियार वो इस्तेमाल करता है वो सरकार को पता है क्या करते हैं। तो इसलिए मुझे नहीं लगता, बिकॉज दीज आर कॉन्फ्लिक्टिंग इंटरेस्ट्स, and I don't see much in the judiciary who says no, my independence and my independence, and independence has been thrown to dogs or something. I don't see anybody saying that.
Right. जज साहब बहुत बहुत शुक्रिया,
Thank
and
you.
आपने इतना वक्त दिया, and today now participation can be there. I'm sure this would hugely benefit our viewers.